Everyone. We're just going to wait a couple more minutes as all the people who have registered for this webinar are coming in. I can just see them coming up on the screen now, and we've got some from Auckland and Matakana. What's it like at Matakana this morning? I bet the weather's beautiful. I always like that place. It's lovely. Auckland, Ashburton, Christchurch, and so on. We're going to have a good geographic spread for this webinar today. And the numbers are climbing rapidly, so I'll just chat along here for another couple of minutes and watch all the registrations come in. We've had some great questions come in, which I'll talk through once Hamish has got through his introduction. We've had some very good questions, so we'll launch into those shortly. So I think we're pretty well ready to go. We've got a very good audience, so away we go. So welcome everyone to another Brainstorm Room webinar. The Brainstorm Room is a free, not-for-profit business resource powered and sponsored by E3 Business Accountants. So for today's webinar, we have a special guest, Hamish Douch, who is a partner at the law firm Mortlock McCormack. One of Hamish's specialist fields is shareholder agreements. Now, if you are one of two or more shareholders in a private company, it's a poor decision not to have a shareholders agreement. When you go into business with another person or buy into an existing company, you'll most likely see nothing but growth and upside, and you'll be positively focused on just how good the future looks and what great people all the other shareholders in the trust in the business are. You can trust each other so much that you're willing to tip in thousands of dollars, even hundreds of thousands, sometimes millions of dollars, because your fellow shareholders, you can trust them. You're all pragmatic, sensible business people, and you know that if any problems occur, you'll work it out. Right. Well, if that's what you believe, then stick with us for the next 60 minutes, and you'll start to see just how complicated a business relationship can get. So thanks for all the questions that you sent in when you registered for the webinar, and we'll also be taking live questions, which I will moderate and put to Hamish during the webinar. So if you have a question, just type it in, and we'll see it come up on the monitor here. So if Hamish does not get to answer your question today, he'll get back to you within a couple of days with his answer. So welcome, Hamish. We really appreciate your time and professional expertise here today. So perhaps if you start with an overview of what a shareholders agreement is all about, why you highly recommend agreements for shareholders, and what goes into an agreement, and then what can go wrong if you don't have one. So welcome, Hamish.
Thanks, Jamie. Thanks for that introduction. Look, a shareholders agreement, as Jamie was talking about there, is something that I think is very crucial at the start of any business relationship. I like to think of it as a great investment in the future that you have with your fellow shareholders. Jamie described there in his introduction the typical scenario that everything's great, you think the people you're working with are wonderful, and you are very confident that you will manage the business very well. I often refer to this as the honeymoon period, where everyone is positive and all rowing in the same direction. Usually people in a privately held company, which is predominantly what we're talking about today, will be friends, relations, the person next door, someone you know through some other means to come in, or it could be that you are buying into an existing business. Generally, however, you are in what we'd call a closely held small company. You'll be committed to common goals. You will want to operate the company in a positive, forward-looking manner. You will have ideas between you all of how it should operate. I think one of the great things about a shareholders agreement and the work that goes into it from the shareholders at the start is that ability to have a conversation with one another and decide what each of you want. So I've had some people coming in to talk about a shareholders agreement where they're going to set up a new business. And I've had, for example, one shareholder saying, look, my idea is I'm going to spend 5 hours a week in the business, I'm going to spend the rest of the time on the beach, and I want to sit back and get an income. But I want to also retain my shareholding for as long as I'm alive. Others are going, hang on a minute, I don't want that at all. I want to be involved in this very hard for 2 years, and then I want us to sell the business and move on. So what I'm saying from that is what you get is you can get a disparate idea of what people want out of their shareholders agreement and their company. And the shareholders agreement, if nothing else, it's a great chance for you all to agree that you are on the same page and that you all are going forwards in the same direction. People often ask me what should go into a shareholders agreement. There are a huge number of clauses that go into that which cover everything from things such as a distribution policy, i.e. should you be retaining your funds within the company or should you be paying out dividends every year? What are exit strategies? What is to happen if someone dies? What is to happen if someone can no longer work in the business? What is to happen if someone is disabled? How do you introduce a new business partner? People often will say to me, why do I need to invest in a shareholders agreement? I found a template on the internet. That's great, and it may give you some guidance, but really what the role of your trusted advisor, your lawyer, your accountant, etc., who is dealing with you on a shareholders agreement is to tease out all those specific issues for your company. Most companies have some differences from everything else. I'm a lawyer. We have differences from other law firms in the way we operate. So that is a key part of the shareholders agreement to tease things out. Jamie also mentioned there what can go wrong. I have seen some agreements or some companies where people don't have an agreement, where, for example, one person has tipped some money in to keep the business going, and the other one has said, no, I'm not going to tip the money in. Generally, with a shareholders agreement, what you'll have is some clause saying that if someone's put more money in, the other person must match it, and there's a debt owed. Without a shareholders agreement, all you have is something called a current account in the company. When you are doing a shareholders agreement, it is important that you have talked through it, you get a draft, you have a look at it, you consider it, you decide whether or not it is right for you before you enter into it. Don't feel bad about coming back and asking questions about it and or an understanding of exactly what everything means. Jamie, you mentioned that you had a few questions there. I think rather than sort of trying to have me just lecturing to the camera for the next hour, it would be great if you do have some specific questions that people have and I can maybe answer them.
Right. Well, one question that's come up, well, several of them have come up and been repeated, is the relationship between a shareholders agreement and the Constitution. Now, the company Constitution, either it's customised for a particular circumstance or it's a default one. Now, maybe just a minute explaining the difference between a customised shareholders agreement and a customised Constitution. Where do they fit? What's available to the public and what's private and confidential amongst the shareholders?
Okay, thanks, Jamie. A constitution governs the company and sets out the right, duties and powers. Generally, a company is governed or the rules relating how you operate a company are under the Companies Act, which was written in 1993. There is no requirement to have a constitution, but a lot of companies will have it. A constitution is accessible on the Companies Office Register, i.e. anyone who wants to can go in and have a look at your constitution and can see what you have provided for in the governance of your company. So it is a publicly searchable document. Generally speaking, in that regard, it is probably a bit more bland than you may have in a shareholders agreement. A shareholders agreement is a specific agreement between the shareholders which sets out the rules of how the shareholders will deal with one another and the company. It is called a shareholders agreement for a reason. It can provide a framework to deal with certain events. So when something goes wrong or something goes well, how will you deal with that? Again, there is no requirement to have a shareholders agreement, although I believe, and I think you do, Jamie, as well, as we've talked over the years, it is a good investment to make into your company, into your future business relationship. And probably the most important thing about the shareholders agreement in relation to the difference between it and a constitution is that a shareholders agreement is a private document between the shareholders. It is not publicly accessible. It is not searchable on any register. What that means is that shareholders themselves can go into greater depth and greater detail in a shareholders agreement governing their relationship with one another and with the company than they would in a constitution. So they can bare your soul a bit more than you would in a constitution.
Oh, thanks, Hamish. One of the questions that we had come in was there was 5 shareholders and they're coming together to form a new business and they're concerned about the cost because they feel that each of the individual shareholders will need legal representation. So is there a lead lawyer that maybe would draft the agreement and then that goes out to the individual shareholders who each then have to get legal advice and support? that seems quite convoluted and expensive. Is that just the way it is, or is there a shortcut that would be cost effective?
Thanks, Jamie. You have to look at this as an investment. You're going into a business with a number of other people. You don't know what they all feel and what they want, but this is an important document to set out what they do want. To answer your question, though, more specifically, generally speaking, the solicitor for the company will draft the shareholders agreement. That may also be the solicitor for one of the parties to the shareholders agreement, but it is quite important that they are advised to draft the agreement on the basis that they're operating for the company and therefore the shareholders as a whole, i.e. they're not favouring one particular shareholder over another. So generally speaking, in a shareholders agreement, you will have equal rights attaching to the shares. Now, you may have, of course, that someone has established the company and they have greater rights than someone else, but the important thing is that the solicitor for the company has explained to everyone the document and also, more importantly, the differences there may be between certain people. So you will get a draft from the company's lawyer, and then if each individual shareholder wishes to obtain independent legal advice, they can, of course, do so, and I think the company's lawyer would recommend that they do so. However, there is no specific requirement for them to do so. My recommendation is that you should, at least one of you should get it looked at by another lawyer, and I go back to this point that I will harp on about a bit during this seminar, that I believe you have to look at this as an investment. When you go and establish a company, you are getting together with other people, a number of other people, you are forming a close business relationship with them. You need to be confident that things are covered in your business relationship, and that if you do run into difficulties down the track, or there is a difference of opinion, you know how you're going to deal with it.
Okay, thanks, Hamish. Question here, what's the difference between a partnership agreement and a shareholders agreement?
So a partnership is a form of business relationship, and you will have however many partners you have in that relationship, and they will be operating together in a separate, in a partnership which is a different relationship than a company. Generally, a partnership is a number of people operating together, as opposed to a company, which is an entity which sits there on its side, the company, and there are shareholders within the company. However, generally, you will have similar clauses in a partnership agreement and a shareholders agreement, as although it is a different entity or different trading entity, you generally want to cover off the same aspects, considerations between the two documents.
Another one here, can a shareholders agreement be verbal?
Oh gosh, you take me back to the early days of law here, Jamie. Look, in this country, an agreement relating to land must be in writing to be enforceable, not necessarily for other agreements. The difficulty, though, with a verbal agreement, and this is the problem that we often run into, is how do you prove what was agreed? So at least with a written agreement, you have it written down. It is there in front of you, and it should be able to be looked at and to be interpreted by anyone who's looking at it. The difficulty with a verbal agreement is it's a he said, I said, she said, they said. So to answer your question, yes, it can be verbal, but how will you rely on that, and how will you prove what you'd agreed if anything were to happen?
All right. Here's a good one. Two shareholders are coming together to form a company. One has the money and the other one doesn't. They're both going to work in the company, but the person without the money is trying to say, I'm going to bring my intellectual property, my knowledge, and sweat equity. You can put in 100,000. I'm going to put in 100,000's worth of IP. How do you reconcile that?
Well, a shareholders agreement will deal with how you are doing that. So, for example, you can say, as you've just said there, I'll put in some money as getting us going, and the other person will put in their sweat equity, their intellectual capital, for want of a better word. As long as you've got it recorded, you can deal with that in any way you wish. So it could be, as you say, one of them's working more hours in the company, one of them's working fewer. You could deal with the dividend policy, that one gets more than the other to compensate for that. But you can also have a dividend policy, or you can also have a returns from the company that are equal. So there is no hard and fast rule that you have to put in the same amount of money, and often you don't. Often, as you've pointed out, or as the question was, there is different inputs from different people into the company. So you can deal with it, and you simply record that in the shareholders agreement as the contributions that each of you are making, whether monetary, intellectual property, sweat equity, etc.
If if a shareholder is also an employee, does one contract or agreement override the other? We know employment law is very strong, and there's endless instances where court cases have been over employment law and employment agreements. How does that fit in with a shareholder agreement? What's the overlap? What has overriding power in a difficult situation?
Okay, so a shareholders agreement is dealing with you generally as a shareholder. That's what it's called, that's what it means. So as a shareholder, you are a private individual or a trust or another company or an entity that holds shares in a business. So the shareholder agreement deals with the way in which you interact with one another as a shareholder of the company. So that is as the owner of the company. An employment agreement is something that everybody should have, a written employment agreement, and indeed must have. And that deals with your status as an employee of the company. So you can be in a company in a number of different scenarios or issues, roles. So you could be a shareholder, you could be, say, a director, and you could also be an employee. Every company should have, with all their employees, an employment agreement. As to what trumps, for want of a better word, you have to be conscious that if you're a shareholder and director but want to take an action against the company as an employee, you're actually taking an action against your own entity. So you do have to wonder the sensibility of that. And I suspect you'll get fairly short shrift if you were to go to the employment court and complain that the directors, one of whom you are, have acted against you and not in good faith as an employee. So I think it is very important that you have the shareholders agreement, which also sets out your role as an employee, but you must also make sure that there is an employment agreement, and you need to work out between yourselves as to how that is going to work, the specific roles that you have in the company. You should get compensated for being an employee, but you may also get compensated through being a director and or a shareholder.
Companies that are poised for growth, should they have, therefore, a clause in their shareholders agreement to enable more shares to be issued, or does that mean that existing shareholders are diluted in their percentage of the ownership of the company when other and new shareholders are introduced? Should that be anticipated way ahead of time when the shareholders agreement is first drafted?
Yeah, so a company can issue shares. There are certain requirements under the Companies Act for how you will issue those shares, and they must comply with that. Generally speaking, in a shareholders agreement, you'll have something called preemptive rights. And a preemptive right generally provides that the existing shareholders can, particularly on sale, make an offer to match the offer that someone else has made to purchase the shares, such that people don't get diluted and in fact can gain a larger shareholding within the company to enable them to maintain parity or get better than parity with their shareholding. So that's through a preemptive right generally on the sale. In terms of issue of shares, you have to say that what is the reason that you're issuing those shares? And often in that case, you mentioned growth there. So people are probably issuing the shares, or sorry, the company is probably issuing the shares because it wishes to get a greater equity into the company, because after all, that's what shares are, they're equity in a company. So you are growing the capital base of the company to enable it, for example, to expand, to take over another business, etc. So yes, generally speaking, the existing shareholders would have and should have the right to also contribute and take up part of that equity raise. But you also have to be careful that are you going to stymie the company by saying it can only be those individuals? Because if there is a need for growth and there is a need for a lot of equity and a lot of capital, then do you need to bring in a third party, an external party, to enable them to grow the company?
Hamish, I'm going to go to one of the screen questions here because it's getting upvoted. Right up your alley, what does a shareholders agreement typically cost? You knew that was coming.
Oh, I've been waiting for this one. Look, Jamie, it is hard to say. I don't think there's any hard and fast rule for that. And I know probably that's the last thing people want to hear. But I would think you're looking at somewhere between $2,500 to $5,000 as an investment in your company, putting that shareholders agreement in place. So often that will involve the initial discussions, and then drafting the agreement, and coming back with any questions you've got, and then an answer from that and putting one into place. Now, of course, the costs will vary depending on the number of shareholders you've got, depending on how much preparatory work everyone has done, depending on what you want to cover in the future, depending on whether you want to have a buy-sell agreement. I would think that's probably where you're looking at the range of it, in that sort of range for a closely held private company. But it does depend on the circumstances at the time. And I think the best thing when you're getting a shareholders agreement is to try and get an estimate of the costs up front. But also ask that your lawyer who's drafting it will tell you if, because of the complexity or the future questions coming in, that it may in fact go over what the estimate at the start is. At least that way you have the chance to pause or say, no, we're comfortable where it sits now, or yes, we want to make that future investment.
You slipped into that explanation, buy-sell.
Sure.
Can you spend a few minutes explaining what the buy-sell part of a shareholders agreement is, and does that relate to insurance? That's probably another question, but do the buy-sell explanation first and then go into recommended insurances.
Yeah, sure, thanks. So you don't have to have a buy-sell agreement, but a buy-sell agreement is often deals with, it'll be referred to in the shareholders agreement. I actually like to have it as a separate agreement sitting alongside the shareholders agreement as well, and it deals with insurance. We'll come back to the insurance. I think you're going to ask me that question in a minute.
Yep.
But what the buy-sell does is generally contemplate what is going to happen if there is a disablement, a death, or some other permanent disability to a shareholder, and how you will then trigger the transfer of shares between the shareholders. So what you're trying to get to is an agreed mechanism for if someone, for example, dies, how their shares will be dealt with in the company. Because of course, shares can be dealt with through someone's will, and they do stay with the person and with the estate. So unless you provided for in the shareholders agreement what is to happen in those particular circumstances, they just form part of the estate of the deceased. So I like to put in there in my shareholders agreements what is to happen on death of a shareholder. And the example I like often to say is, do you want to be in business with your ex-partner's new husband's lawyer, for example? Because that's the sort of thing which I'm saying can happen, that, you know, if they've got a trust and they think they've got shares in the business, you've maybe never met this person, and suddenly they're turning up and saying, I'm a shareholder in your business. And you're like, hang on, I got into bed's probably the wrong expression. I got into this company, I should say, with Jill, my friend Jill, and we were operating this business. If Jill's no longer here, then I want the ability to buy Jill's shares from her estate at a fair value to ensure that I can bring in someone to try and replace Jill for me. I don't necessarily want the person who's 2 or 3 removed, who has no skills or experience in this business, or this the business that we're doing and all this company, and them to come along and say, I'm now a shareholder and I want to have a rights and input into the way that we're going to operate this business and this company.
Okay, so the insurance part of it, you want to step into that now and just talk through what insurances are recommended.
Okay, so I mentioned there in the buy-sell agreement that it deals with buying potentially the shares. So often you'll look at a business and you'll go, and you've mentioned, Jamie, that one of the reasons you go into business with people is because you think you're going to grow this business and you're going to get into a very good business that's going to increase in value. So what you then do, if someone dies or is permanently disabled and can no longer work in that business and therefore should no longer be a shareholder, how do you buy their shares? Now, it could be possible that you've got money put aside elsewhere to enable you to buy the shares. It could be possible there's retained earnings in the company which can be paid out, etc. However, often there isn't that. So what you would often have is you would have a life insurance policy or a permanent disablement policy or something similar over each other's lives and or over the health of that individual. And what that does, it provides some security for the company and the shareholders still in there to have an insurance policy which will pay out in certain circumstances, which will then be used to buy the shares of the person who has left the company. So you have a very specific provision for the way this is going to work. You'll often have someone called a stakeholder who will hold the proceeds of the insurance. So Jill dies, the insurance company pays out to Jill's or to the company's, say, accountant, who is holding that money on behalf of all the shareholders. You then go through the mechanism within the buy-sell agreement and the shareholders agreement to value the company and therefore value the shares. So Jill's shares get valued. Then what happens is the money that is being held by that stakeholder is utilised to pay to, in this instance, Jill's estate, and Jill's estate will sell the shares to the remaining shareholder and or shareholders in the company. So what this gives is, obviously for Jill, it's not great because Jill's no longer with us, but it gives her estate and a payout from the company so that they know that they have an asset there which can be collected, i.e. the shares in the company, and there is a payment to be made. And it allows the remaining shareholders to know that they have the comfort of not having to fund themselves and or through the company the payout to Jill's estate. Often you'll have in there that you have a mechanism for revaluing the shares quite regularly. That might be every 1, 2, 3 years, and there'll be a relatively strict mechanism in there for the way that is going to occur. And that means that you can adjust your insurance that you have in place at the time to ensure that you have the correct insurances in place and the correct quantum for the insurance in place. So it is quite important to go through that mechanism as well to ensure there is that valuation, there are those valuations going on. You also have to be aware with it that you have to consider things like current accounts, because people may have a current account with the company, and that is just their money that they are either owed to the company and or the company owes them, and that also may need to be paid out as well. So what the insurance does is just provide a security blanket for all of the shareholders to know that by having to buy out a shareholder, you're not going to completely beggar the company and all the remaining shareholders. It's a bit different to key person insurance. So key person insurance is the company itself trying to replace that individual. This is the shareholders themselves trying to replace each other as shareholders.
Thanks, Hamish. Look, I'm going to go to some of the questions that are coming in on the monitor here. Persephone asked, what do we need to do in regards to dividends and advances paid out?
Thanks, Persephone. Good question. I know Persephone, so that is a good question. So you need to agree on what you are doing with your dividend policy. So that is one of the things that I think it is important to have in a shareholders agreement, your dividend policy. So for example, you may say that for the first 5 years or until we get to a turnover of X, we're going to reinvest the profit to grow that. Other times you'll say, no, we are going to say that we are in a mature or getting towards a mature business, so we will ensure that the dividends are paid out as and when they accrue into the company. With anything, it's important to also have a business plan so that hopefully the board have agreed on a business plan for the company. And one of the things they'll often have in the business plan is their idea of the budget and following through from the budget, the dividend policy that they are aiming for that year. Now, of course, things can happen. We had a global pandemic last year, and I suspect some people had to tear up their business plans and start again. But generally speaking, you need to have your business plan, and that will also potentially have your dividends written within it, your dividend theory, but your dividend policy and the profits and the payment of the same should all be dealt with also in your shareholders agreement. It goes back to that point I made at the start. I think one of the great things about a shareholders agreement is to get people to talk, to get everyone on the same page. So I mentioned at the start, someone who wants to work a few hours a week, lie on the beach, get the profits, someone else who wants to say, no, we're going to drive it really hard, then sell the business on in a few years and take the capital out. So that is a similar sort of thing you need to deal with your dividend policy as to how you're going to deal with that and make sure you've got it written down.
Hamish, I think one of probably the 3 words that you use over and over again when you're sitting with clients and drafting a shareholders agreement is probably what happens if. What happens if? And those questions need to be asked over and over again to tease out all of the things that can, all the good stuff that can happen as well. As you mentioned, dividends, a distribution of profits, not just how to deal with something that's gone wrong, but hey, how to deal with the good stuff that happens. Now, question in from James here: is a shareholder agreement a paper copy binding before it is registered in the shareholder register?
So sorry, just run that. Is it binding before it's
shareholder agreement binding before it is registered in the shareholder register?
A shareholders agreement, as I've said to you, I believe should be in writing. So I think we're over that hurdle that we've decided, yes, we've discussed what we want, and then we actually put it into place. Until everyone has signed it, it would be hard to say that everyone has agreed to it, although you could run an argument that everyone has said, yes, we agree to what the final is, and until we've actually all signed it, we agree we're bound by it. But to answer your question, my belief is the best thing is once you've made the decision to a shareholders agreement, move it forward as quickly as you can, get it signed up. Then once it's signed, you really don't need to hopefully utilize it all the time. You've agreed what you're going to do. It is a signed document though, and no one can then turn around and say, oh, I didn't agree with that, because they've signed the agreement itself. So look, to answer, I would say that you must sign it you should sign it as soon as you can to stop any debate. One of the things I always say with people when I'm talking to them also, you've mentioned the what ifs there, don't run a business in such a way that the only people who make money from it are your lawyers, i.e. agree, and then you, the two of you, or the 5 of you, the 20 of you in the shareholders agreement have all agreed what is to happen in certain scenarios. If you haven't got a binding agreement and you haven't signed it and you haven't agreed that that's what you want, then you're going to get a whole lot of lawyers who are all arguing over what particular provisions mean, and you don't really want that.
A question in from Matthias: can you clarify your point about current accounts and how should a shareholders agreement fit into that? So a little bit more story about shareholder current accounts.
Okay, yeah. So a current account is an account that the shareholder runs with the company. I know that's, I've sort of just said the 2 words, but what it means is that as a shareholder, you may have advanced monies into the company. You may take drawings from the company over time. You may declare a shareholder salary in due course. You may declare dividends, etc. All of those are run through an account, for want of a better word, which is an accounting exercise with pluses and minuses into it, which says that the company may owe you some money and or you may owe the company money. So what it means by that is that there is an obligation either owed to you by the company or that you owe to the company. Now, I'm sure, Jamie, when you're running accounts for people, you'll often tell them that it's not great to have an overdrawn current account for various reasons, use of money, interest, etc. So generally speaking, we try and have current accounts and credit. What I mean by that is that you are owed more money by the company than the company owes you. That is an obligation of the company and can be called up at any time. So it is a debt the company owes. Generally, it's not secured. So generally, it's what we call an unsecured debt. But it sits there and it's an obligation of the company. And people will see in their accounts at the end of the year, there'll be shareholder current accounts, and there will be a figure in the books of the company, the accounts of the company, saying what that is. What a shareholders agreement will cover off with current accounts is things such as equalization of current accounts, i.e. should every so often you have a look at the current accounts and say, Bill's taken out more than Jack, therefore Jack should get a payment to equalize the current accounts, and or Bill should pay some money into the company. You'll also deal with some of the things we talked about through the buy-sell agreement and death, total permanent disablement, etc. If you're no longer involved in the company, you don't really want the company to be owing you money. So part of what you'll also deal with there is that if you exit as a shareholder of the company, your current account should be paid out. If it's in deficit, you should pay money in. If it's in credit, then you should be paid out your current account when you exit the company. So one of the things that you want to have with the insurance is to ensure that you have sufficient monies to cover the current account, and or if you don't have sufficient monies to cover the current account, the knowledge that the other shareholders can tip money in to ensure the current account can be paid out, and that of course would credit their current account, and or the company itself can go and borrow some funds to pay out the current account of the person who is leaving the company.
Thanks, Hamish. Interesting question in from Kim. What is the recommendation if one shareholder becomes ill and cannot work for 6 months? So I guess the other side of that question is, how do you anticipate that, and what is some typical wording that you would have in a shareholders agreement to cover the illness of one of the shareholders?
Yeah, so I think I mentioned earlier that you may have several different roles within the company. So as a shareholder, it is simply that you are a shareholder. Now, you often have that you're also an employee and or working in the company, you're a director of the company, etc. And often it's quite crucial that each of the shareholders is working in the company. So what you've done is you've come together, you've established a company to operate your business, and you've decided that you're all going to be shareholders in it. So you'll cover off in your shareholders agreement what is to happen if one of you is not able to work in the business. And that's part of the reason I talked about the insurance there, that you'll often have specific wording for what triggers a payment out for total permanent disablement, what triggers a payment for illness, what triggers death is pretty obvious. So the wording that you will have in there will have to tie into any insurance that you have. If you don't have insurance, which some people don't, and that's perfectly acceptable, and there's no problems with that, except if the business goes very well and how do you pay out, you will have rules in there for what that means. So you may say that if someone's got an illness and it's likely they're going to return to work in, say, 6 months' time, that they can remain as a shareholder, you don't trigger anything, they can maybe take lesser drawings from the company during that time. But when they are fit and healthy and ready to come back to work, they come back in and they step back into the shoes they were previously in and continue to operate in that company in the role that they previously had.
James has asked a question to expand on Kim's question, which you've answered very thoroughly. And James asks, what if one or more shareholders do not continue to do their jobs, in inverted commas, that they were supposed to be doing in lieu of money for equity?
Yeah, so this is the sort of the dispute resolution type provisions that you have in there. So the shareholders agreement, I think we're well established, it covers the roles and responsibilities that people should have in the company. If someone is not performing their roles and responsibilities, then hopefully the shareholders agreement would cover what is to happen in that instance. So it may say, for example, that if you've decided not to work in there, that you must sell your shares, and there may be a requirement that the valuation of those shares takes into account the fact that you're not performing your role in the company. It may say that although there is a valuation of the shares, you get paid out over time, for example, so that there is a disincentive to not do your job. So what you are looking there for is the ability to cover off in the shareholders agreement the specific roles, but then also the mechanism for dealing with someone who is not performing their specific roles and what that will mean for them.
Right, a question from Meredith. Shareholders agreement in place, some years later it is contested by one of the parties. How clear that this was his intention or their intention from the outset? How well will the agreement stand up? So I guess it's contestability of a shareholders agreement when there's a dispute some years down the track.
Okay, well, as I've said to you, the shareholders agreement should be in writing, it should be signed. You're going to find it hard, I would have thought, to say, actually, I didn't know what I was doing when I signed it, I just signed it. Because you have signed it, you have had the ability to take it away, you have had a look at it, you have had some consideration of it, you have had the thought to get some advice on what it does mean and what it does not mean in certain circumstances. But look, nothing is 100% secure. Times change, people's views and what they've agreed change. However, you've got a much better starting argument or starting position for saying, this is what we've agreed. And then it becomes someone else to prove that, no, actually, I didn't do that, or I didn't mean that, or no, we never agreed to that. To say, then simply to say, oh, look, I didn't know what I was signing. I didn't have a shareholders agreement, and this is what I think we were doing. If you've got a shareholders agreement, you've got a signed document. Everyone has put their signature on it. So it is very hard, I would have thought, for someone to then say, look, I had no idea what that meant. I didn't understand it. I didn't want to sign that. I didn't know that it meant this particular thing. Because you've signed it, you have had the chance to have a look at that shareholders agreement. It's quite an important document for your company, and it deals with all the aspects of the company that you've got. It's very hard for you then to turn around and say, I didn't sign it, didn't mean it, I meant something entirely different.
Right, excellent. For those who have come in recently into the webinar, it will be recorded. It is being recorded, and we will send out a link shortly. Now, here's another question, husband and wife, should they have a shareholders agreement if they're 50-50 or 60-40 or 30-70 in a company that they both own?
Well, one would like to say hopefully not, but look, the amount of separations and relationship breakdowns that we see nowadays, we see a lot of them. It's unfortunate it happens. A shareholders agreement, shares in a company, if they're a husband or wife setting up together, are relationship property, so they will need to be separated and divided between you. So if you don't have a shareholders agreement, that just forms yet another thing to argue about and discuss about. So I believe in that instance that a shareholders agreement still is probably a necessary document. Now, it may not be quite as complex as some others, because hopefully you're in a partnership. When I say a partnership, I mean a relationship partnership. But it is important to have it. It also deals with, what if one of you, say, dies and one of you partners, and what happens if you've got, say, a merged family with children who are different between the two partners, the husband and wife, or the people in the relationship, and how do you deal with those things? So look, Jamie, I believe it is important to consider in that instance, because it will potentially come down the road where if there is any form of disagreement or split, it is just another thing to be dealt with. Whereas if you deal with it now, it's one box that you've dealt with, you've ticked off, you've dealt with the way it's going to occur, and it often will mean that makes your separation, if it does come to that, an easier thing to deal with in the future.
All right, thank you. Now, one question's come in here. What if we don't have a shareholders agreement when we opened the company, and later we want a shareholders agreement, but now two shareholders agree on some matters, but one major shareholder denies? So what are the general rights for minor shareholders? So they don't have a shareholders agreement. Sounds like they're trying to put one together, but they've got some friction there.
Okay, so you'd probably look at the Constitution to see if you have a Constitution for minority shareholder rights. And if you don't have a Constitution as well, then you go to the Companies Act. So the Companies Act, if you don't have either of those documents, the Companies Act is generally the key item to look at, and that will deal with how minority and in fact majority shareholders are protected. So there are requirements, there are rules in there for how minority shareholders can be protected and looked after. But look, unfortunately, you're generally going to find that some transactions can be pushed through by the majority shareholder without necessarily the consent of the minority shareholder. So this goes back to the point I said at the start, and I think, Jamie, you talked about as well. A shareholders agreement is a key document when you're establishing the company, because you can agree and tease out those things there, and it means that at a later date you don't get this unfortunate situation that has occurred where one shareholder is dominating the other shareholders. The whole point of the shareholders agreement is it governs your relationship with each other as shareholders. You've agreed most things, hopefully everything, but there'll be some things you may not agree. And it will also have a dispute resolution mechanism in it, i.e. if you don't agree, how you will now deal with those aspects.
Tag-along clauses.
Sure.
What on earth is a tag-along clause?
Okay, so there's a couple of things that I would refer to there. You have something generally called a tag-along and a drag-along. What they are dealing with is the ability, if the company and or the business is sold, to drag or tag yourself with someone who is selling it. So if someone is, say, an 80% shareholder in a business, and it doesn't need in a company, and it doesn't need to be 80%, I'm just using this as an example, and they wish to sell their shares to someone because someone's offered them a great price for those shares, and they're saying, yep, I want, this is the time to sell, this is the time to move on. What the tag-along does is it gives the minority shareholders the rights to tag along, i.e. come along with that larger shareholder on the same terms and conditions. So that means that they will also get the same monetary value that the majority shareholder gets for those shares. And they can also say to the person buying the shares, we've got a shareholders agreement here. Unless you're taking all our shares, you can't get any of them. So we're going to tag along, we're going to come along with you. The benefit, of course, for that minority shareholder is that they get the benefit of the price for the sale of the company, but also what they've got is they're not necessarily going to be stuck with a new shareholder who they haven't met or may not know, and they may not want to be in business with that new shareholder. So this way, they can be tagged along. They can make the right to tag along, and they can say, I also want to sell my shares on those same terms and conditions. A drag along is sort of the opposite of that, but it has the same effect, where the majority shareholder can say, or a certain percent of shareholders, I'm going to sell my shares. You need to be dragged along, so I can drag you along with me and make you also sell your shares in the company. So look, it is the drag along and tag along, I think, are very important provisions within the agreement. You do need to establish and agree between you as shareholders what percentages can trigger those particular provisions. Generally speaking, it's between 60 and 90% ownership of the company can trigger the drag along and tag along.
A good question in from Deborah. If company shares are valued at, say, $2 per share, then bring in a new investor with $100,000, is the share value then revalued, and how is share percentage distributed or redistributed? Want me to read that one again?
Yeah, please.
If company shares are valued at, say, $2 per share, and you then bring in a new investor with $100,000, is the share value then revalued, and how is the share percentage redistributed?
Okay, so you've got to be conscious here. There's a couple of things. So that could be the sale of shares by one shareholder for 100, so 50,000 shares if they're worth $2. One shareholder could be selling shares to the new shareholder coming in. So what will happen then is that new shareholder will just come into the company, will own 50,000 shares in the company that were previously owned by someone else. You've got all those things, preemptive rights, which is the ability for someone to say, no, I'm going to match that or not. But in that instance, if it's a sale of shares between an existing shareholder and a new shareholder, then as long as you've followed the rules in the shareholders agreement regarding preemptive rights and how many shares everyone can have and the ability to say, I will buy those shares, then you will have still the same amount of shares, and the new shareholder will take the 50,000 shares it's bought from whoever it wants to take them from. The other thing is an equity raise. So in the first instance, what you've got is it's actually the shareholder themselves who gets the $100,000. In an equity raise, the company is issuing shares in itself. There's certain requirements to go through to enable that to occur. So what that happens, you've increased the capital of the company by $100,000. And that's something we talked about earlier, that it may be needed for expansion or to buy another business. So you've issued more shares in the company. You've signed a certificate to say, the directors signed a certificate to say, we think this is a fair and par value for the shares. And then they will get distributed to that new shareholder who is coming in. Again, I think I just referred to preemptive rights there, that often the existing shareholders will say, I actually want to take up some of those shares myself, so they don't get diluted in the business. But what will generally happen is if new shares are coming in from an external shareholder and all the other shareholders agree, you simply now have more shares on issue. Therefore, the shareholding that the existing shareholders had, they'll have the same number of shares, but as a percentage of the total shares, they'll have a lesser number of shares. That may also involve an update to the shareholders agreement. If nothing else, the new party will need to sign what's called a deed of ascension, which says that they agree that they are bound by the shareholders agreement that the other shareholders have signed, as if they'd signed it at the time that shareholders agreement was signed.
Yeah, thanks, Hamish. Look, there's a number of questions coming in about tax deductibility. What's tax deductible? What's not? Is life insurance tax deductible? Is the formation cost of a shareholders agreement tax deductible? I think we can answer those in-house. We've got your email addresses, so we'll respond to those from E3's tax team, and we can go directly and answer those questions, because when we get to tax, there's quite a number of complexities, and I thought we'll just leave Hamish on the legal side of it, and we will specifically answer those questions via email later today or tomorrow. So they're all good questions about what's tax deductible and what's not. It's a wee bit of a
Can I just jump in there? Sorry, I 100% agree with that. It is incredibly important when you're doing this that you've got some tax and accounting advice. I know the law. I like to think I know a bit about tax and a bit about accounting, but go to your accountant. They're the experts in this. They're the ones who are going to provide that specific advice to you. Don't try and wing it. Don't try and come up with it yourself. Your trusted advisors are called trusted advisors because you trust them to give you advice. You must invest in your business and your company, and you've got to get advice from the right people.
Thanks, Hamish. I appreciate that plug, and I'll put one in for you. A lot of people have asked what shareholder agreements cost. Well, Hamish, I can see sitting in the car park here, has a modest car. To me, that's a good indication that his charge-out rate is quite fair. So sorry to put that one on you, Hamish. But now, John asked about a phantom shareholder agreement. How does the likes of phantom shareholder agreement apply when dealing with dispute resolution? So I'm not quite sure what a phantom shareholder agreement is. Maybe it's one that doesn't exist. But have you heard of that expression before, Hamish?
No, I'm not quite sure what John is driving at there, but I go back to that point that a signed shareholder agreement should cover a dispute resolution mechanism. So you will have in there, you'll have typical scenarios how you will deal with disputes, whether it's you just have a look at the agreement and you go, okay, we weren't sure on this, but the agreement's very clear, this is what we're going to do. Or that you say we're going to have a completely different outcome to this dispute because we've discussed with it ourselves and we're comfortable with the outcome we've come to, which you can do, of course. Maybe you've got a third party who's coming in and trying to resolve the dispute for you by either mediating between you or is making a ruling, for want of a better word. You may also have a mediation provision, which I just referred to. You may go to court, which is sort of a bit of a last resort. You can arbitrate. And you may even have something which I like to refer to as Russian roulette, whereas if you really can't get to a decision between you, that one person has the ability to buy out the other. And I like to often put in a Russian roulette clause into these agreements where both of you will basically bid your highest price. And the person who buys the highest price buys the shares of the other one at that price. That's quite fun. I've only done it a couple of times, but it's sort of a bit like a tender for a property. You open all the envelopes up and the person who's bid the most gets to buy the shares of the other person. So the person who's bid the most obviously sees the most value, or they most want the shares. And what that means for the other person is that they have got the maximum value they can extract from the company.
And is that a real Russian roulette? Do you call that the Russian roulette clause? And does that really exist inside a shareholders agreement?
Yeah, it often does. Some people get quite excited when they see that, and they sort of think it's a great idea. But I mean, you can have any other means for that as well. I mean, often you'll have that, I mentioned earlier, you want to get your shares valued, and that's often covers off things like for your buy-sell agreement, but also covers off that you've got a valuation mechanism in place that if anything is to happen, you know what it is. So you're not scrambling around to get a valuation done at the time. You've agreed on the mechanism for establishing the valuation, which I think, Jamie, you'd be the first to say is not just based on your assets. There's a complex scenario in that, goodwill, all those sort of things goes into a valuation. But it's quite useful to have a mechanism for that. And this is more for the situation where both people would say, I want to buy the shares, or I want to sell the shares. So you can have a mechanism for one to buy out the other.
Here's a question in from Jane. What needs to be considered when gifting shares to a family member who will be an employee, director, shareholder? So I guess it's one of those typical family situations where you have family members inside a company, and then do you impose a shareholders agreement on family members, and then how do you go about gifting shares to family members? Okay,
well, I think we've covered pretty well. You do need a shareholders agreement. So your shareholders agreement will be one that the family member, if it's a gifting of existing shares, then they're going to sign that document called the deed of ascension, which means they've come into the company and they've accepted that the shareholders agreement that was already in place must apply to them and does in fact apply to them. So that will sit alongside the company documentation. In terms of the gifting, that is your choice, of course. Gift duty, well, we used to have to do a gifting program. There's no requirement now. You have to sign something called a certificate of solvency if you're going to make a gift, to say that you're solvent at the time you make that gift to someone, such that you are not making a gift when you can't pay your debt, so that if you were to become bankrupt, someone can't turn around and say, well, you made this gift when you couldn't actually afford to make it, and the whole reason you've done that is to defeat the interest of your creditors. That's a slight segue into something different. I think what the question was, though, and specifically saying, should I have a shareholders agreement? Yes, you should. What happens if you fall out with this person? What happens if this person dies? What happens if this person suffers a total permanent disablement? What happens if this person partners or re-partners with someone who you don't want to be in business with. So yes, that person should be required when they are gifted those shares to sign up to the shareholders agreement.
Should a shareholders agreement have limitations on the amount of expenditure taken? So, for instance, there's 4 or 5 shareholders in a company and they need to buy some new premises or new plant and equipment, and the cost is significant, $500,000 maybe. Does that mean in a shareholders agreement, the voting rights, how are voting rights apportioned inside a shareholders agreement to manage the expenditure, especially on capital items?
Yeah, okay. So I've referred to a business plan earlier. Your business plan should cover off what you're hoping to do over the next, whether it's 1 month to 10 years. So at least that'll give you some guidance as to what you're thinking to do. Your business plan will generally be something that relates to more the governance of the company. I know it's a management document, but it's also the governance, which is the directors of the company setting the direction of the company. So the directors have probably said, we want to go and buy a premises to operate from. We think that's going to happen in the future. What you'll cover off in your shareholders agreement is that if you want to spend a certain sum of money, and the amount might be more than $10,000, for example, unless it's in the ordinary course of business. So what I mean by that is paying the wages every week of the $20,000 doesn't need to be approved because it's what you do. But this is a capital item here, which you referred to, buying another business, buying a building, buying a piece of plant and equipment. Yes, you will generally have in there a requirement that for one of those bigger transactions that the shareholders themselves must agree, and you'll have to agree between you on the percentages that must agree. It's silly if there's 3 of you, each of you with 1/3, to say that it must be a 75% shareholding agreement for something, because that means that each of you has an absolute right. All 3 of you must agree. So any of you has a complete right of veto. Now, you may think that's fine, and it may actually be that all 3 of you need to agree. But you want to look at what your shareholding percentage is to decide on who can approve, or the percentage to approve those major transactions. And look, it is important to deal with that because they are big expenditure, and they do potentially change the way in which the company will operate and run. So it is important that everyone gets their chance to have their say on whether or not that should occur.
Right, we've got a couple more questions, and we've only got 3 or 4 minutes left.
Cool.
But here I have a number of slides from a PDF put together by Hamish and his company. They're available online here, and we're just going to put them up on the screen here. So if you download, you can get these PDF, a summary of what Hamish has been talking about today. So there's some really good stuff in here that will help inspire those who are looking to have a shareholders agreement, or maybe make you think about what's missing in your own shareholders agreement. Now, a good question in from Tracy here. If the company has a shareholders agreement, issues new shares, and brings in a new shareholder, does a new shareholders agreement have to be formed, or does the new shareholder have access to the existing agreement and buys in on those terms and conditions?
You can do whatever you want in that instance, but generally speaking, the existing shareholder the new shareholder will sign that deed of ascension, which says, I agree that by taking up these shares in this company, I am bound by the existing shareholders agreement that is in place as if I had signed it at the time. So although you can negotiate, and sometimes there is a requirement to renegotiate a shareholders agreement, particularly if you have an external equity contributor who may, for example, not be working in the business, or may have a competing business or a similar type business, but you still want them to have as a shareholder, you may need to vary the shareholders agreement slightly to cover each of those scenarios. But generally speaking, the existing shareholders agreement is there. It's a well thought out document. It's what the current shareholders agree is the way in which the company should operate. That new shareholder is coming in. They've obviously decided to come in because they like that company. They like the way it's operating. They like the current shareholders. So they should also be bound by that current shareholders agreement with that deed of ascension, which will often should attach the shareholders agreement and any variations to it. They all sign it and say, I'm now new shareholder. I agree that this shareholders agreement applies to me as if I was one of the original signatories to that shareholders agreement.
Right, Hamish, look, sorry to dump this on you, but just at the end, have you got any war stories or any when you cast your mind back, any difficult situations that you've had to resolve, either because a shareholders agreement was incomplete or was there but was unsigned, or that there was no shareholders agreement at all, and you had to bring parties together and try and negotiate a settlement.
Yeah.
Anything come to mind?
Yeah, I think one that I often refer to, one I do remember was actually quite early on in my career, where they did not have a shareholders agreement, the parties, and the business wasn't doing that well, and there was a requirement to tip some money in. And one of the shareholders said, look, I'll put in 50 grand. If you put in, I think it was 70 or 80 at another time. And they said they had a verbal agreement for it. The first shareholder put in $50,000. The second shareholder said, nope, I'm not going to do it. And they didn't put in the money. The company went into liquidation. The shareholder that had put the money in tried to say to the other shareholder, well, you've got to contribute money as well. You've got to compensate me. And they said, show me the shareholders agreement. Show me where I've got to do it. They didn't have any agreement. The person who put the $50,000 in lost the $50,000 as the secured creditors weren't even paid out in full. So the unsecured creditors got nothing. So that person, from the lack of a shareholders agreement, the lack of an investment in a shareholders agreement at the start, lost $50,000, where they would have had a compensatory payment from the other shareholder for at least part of that.
Right, thank you, Hamish. So just to wrap up, download the PDF. We can also send that out to anyone who has registered for today. Thank you for registering. There was a replay, and that's being recorded, and that replay will be made available later today. We'll send out an email to let you know that it's available. So a special thank you to Hamish today. That's a very valuable hour and 1 minute. Excellent, Hamish. I really appreciate that. You've covered an awful lot of ground, and just looking at the responses coming in from the audience, they also want to thank you. So excellent, Hamish. Thank you for your time, and let's hope that some of these people in the audience today will come and talk to you about a shareholders agreement if they don't have one, or they've got a new company idea. Thank you, Hamish.
Thanks, Jamie. My pleasure. It was great.